Now, the SWAPO party has amended its constitution to bar members from contesting as independent candidates in future elections. The amendment comes into effect on Friday this week. To dissect this and unpack it further, this amendment, I'm now joined via Skype by legal analyst Yarukeekuro Ndorokaze. A very good evening, Ndorokaze. Thank you very much for joining us on the program this evening. Ndorokaze, can you hear me?
Yes, I can hear you, but you're breaking in between.
All right, a very good evening. Welcome to the news once more.
Yes, good evening, and thank you for having me.
Right.
Somehow you're breaking up.
All right, let's get into it, and I think our technical technicians will amend or correct as we go forward. What can you make of the amendment as is right now?
Well, if we are to assume that the procedural requirements, such as the notice periods, the quorum as required by Congress, and everybody who should have been invited to Congress was invited in time, and the proceedings on the day were carried out as prescribed within the SWAPO party constitution, I think it's very hard to find any fault with the amendment. One can say it was actually expected to happen. But however one would notice is that it seems the SWAPO party has also adapted to the new normal, as it is called, and it was able to carry out its Congress, which Congress normally would require in excess of around 700 delegates plus, and they were able to do that within the provisions and the abilities and capabilities of what technology presents. So that's one observation that one can make. But otherwise, it's really, I would not be surprised by anything.
Right. Now, in your view, will there be procedural disciplinary proceedings against those who have already indicated to stand as independent candidates in the constituencies, or is it automatic in terms of amendment that have expelled themselves?
Well, I guess there are two ways of addressing that one. As it relates to, one should have regard to the fact that the amendment takes effect from, we are informed, it takes effect from this 11th of September. So it will be with regard to anything that happens from the 11th of September going forward. Now, as it relates to what the process would be, I think the SWAPO party constitution under Article 6.2 still provides that whoever would have found themselves guilty of the deeds or things that would give rise to a possibility of expulsion, they are still expected to go through a process as provided for in Article 6.2, which provides for a fair process that needs to ensue before the expulsion can happen. What it does is that the Constitution now criminalizes or makes it an offense to do that, and the sanction permitted there is an expulsion. But before the expulsion can happen, there is a due process that will still need to be carried out.
Right. But one can't help but wonder, why was SWAPO silent on this matter for all of these years? And did it not see it coming? Because it dates back to 2015.
Well, I cannot speak for the SWAPO party because I don't have a mandate, but because the SWAPO party is the mass movement as it prides itself to be, it's obviously open for public discussion and scrutiny. And one would assume it probably follows, it goes without saying, and it's implied that if you are part of a team, for instance, for practical reasons, if you are part of a team and a team is contesting in a certain competition and you are part of that team, it would highly be unexpected of you to now want to contest against the very same team that you claim to be part of. So it was sort of almost accepted that it follows that you cannot be saying that you are part of the team and now you're competing against the team. And I think the major challenge probably came during the elections of last year, and therefore that probably necessitated the need to close that loophole if that loophole was there. When you have regard to Article 5.1 of the SWAPO Constitution, I think it comes very close to criminalizing or closing or making it an offense, but it really does not specifically state in the terms that the amendment now states. Probably that's why they saw the need to bring in those amendments. But really, for practical purposes, you would have not expected that somebody who claims to be part of a team would still want to compete with a team that he claims to be part of.
Right. Now, Ndorokaze, can the amendment be contested, or is there any recourse in the court of law that one can perhaps take up?
Well, we live in a country that is governed by the rule of law. And if anybody feel aggrieved by anything that was done, the courts are open. We have open courts. However, your question would be, but to go to court on what? If it is probably procedural issues, and those are the ones that I started referring to, if one would say, for instance, there was no proper notice given, or the notice was not given as required by the Constitution, or the quorum that attended the meeting was not met as required by the Constitution, or the process that was followed as prescribed with regards to extraordinary congresses like the one that took place. If you have issues with those, maybe then you can go. But I don't think the substance thereof can really be challenged and challenged successfully. But that does not stop anybody from bringing up the challenge. And whoever feel aggrieved, they have that as an avenue that they could probably explore. But unless the issues are put forward, I'm really not seeing what the possibility of success would be with any challenge with regards to the amendment as it was made yesterday.
Right, so one can safely say that this whole process, the I's were dotted and the T's were crossed. Now,
you cannot say that for certain. Remember, with the law, with every fact that comes apparent or that becomes apparent, the finding might change. If somebody now comes with the facts to speak to a process that was not followed as prescribed, or something that they feel infringes on their rights, then the chance for challenge and possibly succeeding with that challenge would still be there. Remember, the SWAPO party, like many other political organizations in this country, are voluntary organizations which you join if you want to associate with them. And you would associate by the rules as agreed by the collective. And the moment that you feel that these rules are no longer good for you, just as you were free to join, you would also be free to leave.
Right. Now, lastly, because of time constraints, recently there was a number of young people who ended their relationship with SWAPO. Now, with this barring or change to the Constitution, is there a likelihood of an exodus from the party?
Look, what the amendment, the way I understand it, what it provides for is to say, you really need to decide whether you are with us or you're not with us as a party. That's probably the message that they are sending. Now, if you were a member that was committed to the SWAPO party, I'm not seeing how you would find this to be offensive. However, if you wanted to try your luck elsewhere, maybe the party process, you go through the party process and the party process do not produce you as the person to represent the party and you want to try it on your own, you would still be free to leave. And I'm not seeing that as being a response to the amendment, because at the heart of this amendment, the way I see it, it was just there to close a loophole that was there within the party. And it probably would not just be limited to the SWAPO party. You would expect similar approaches from other political parties where they are candidates, because many of them are now undertaking primaries, and whoever do not emerge from those primaries might even want to go it their own way. So maybe other political parties could follow, but if people want to leave, it's still within their rights to do so.
Right, so we have to leave it there. Thank you very much for your analysis and an update regarding the amendment there.